Okay, so 730 is mental disease or defect excluding fitness to proceed. Okay, so 73010 is all definitions, so I'm just going to go through them real quick. An incapacitated person is a person who, as a result of mental disease or defect, lacks the capacity to understand the proceedings against him or to assist in his own defense. An order of examination directs the detention of a person for the purpose of determining if he is an incapacitated person, and that is a maximum of 30 days, if you know from 330. Commissioner means the State Commissioner of Mental Health or the State Commissioner of Mental Retardation and Developmental Disabilities. The Director means the Director of one state hospital operated by an Office of Mental Health or Director of Developmental Center operated by an Office of Mental Retardation and Developmental Disabilities. Or 2, Director of Approved Governmental Hospital. Or 3, the Director of Community Mental Health Services. A qualified psychiatrist means 1, a diplomat of an American Board of Psychiatry and Neurology or eligible to be certified by the board. Or 2, certified by American Osteopathic Board of Neurology and Psychiatry or eligible to be certified by that board. If you already did Mental Hygiene Law Article 9, you will know that that definition of the qualified psychiatrist is the same. Just as a note. Certified psychologist means the person registered as a certified psychologist. Psychiatric examination means qualified psychiatrist or certified psychologist designated by the director to examine the defendant pursuant to the order of the examination. An examination report, the form is promulgated by the state administrator and commissioner, means a report made by a psychiatric examiner, a psychiatric examiner, not 2, a psychiatric examiner on whether the defendant is an incapacitated person. In Mental Hygiene Law, Article 9, it had to be 2 psychiatric examiners. An appropriate institution, hospital operated by 1, the Office of Mental Health or whatever that whole thing is, developmental center operated by the Office of People with Developmental Disabilities, or 2, other qualified and licensed hospital by the Department of Health. 73020, fitness to proceed, generally. 1, after an order of examination is issued by the court, the director must designate now 2 qualified psychiatric examiners to examine the defendant to determine if he is an incapacitated person. 2 qualified psychiatric examiners. There's 2 in Mental Hygiene Law, Article 9. Just trying to make things make sense here. 2, if the defendant is at liberty and upon request of the director, the court may direct that the defendant be confined in a hospital under the examination until the examination is completed. That again, Mental Hygiene Law, Article 9. 3, if the defendant is in custody, examination shall be at a place of custody unless the director determines that the hospital confinement is necessary for an effective examination. 4, hospital confinement pursuant to an order of examination shall be for initial period not exceeding 30 days, can be extended by the court for an additional period not exceeding 30 days. So hospital confinement, examination order, 30 days, extended 30 days. Each psychiatric examiner must prepare an examination report. If the 2 reports are not in agreement, the director must designate another psychiatric examiner. Upon receipt of the reports from the director, the court must give a copy to the defendant and the DA. This is making so much sense now, why they have this on the test. I just don't know why I didn't see it before. 6, statements made by the defendant for the purpose of examination are not admissible in the criminal action in any issue other than his mental condition. Psychiatric examiners are entitled to $50 for each examination and $50 for each court hearing for a total not exceeding $200. So $50 for the examination, $50 for a hearing, not to exceed $200, and they're entitled to traveling fees. If the examiner is a New York State employee, they shall only be entitled to traveling expenses. Of course, we get screwed. Okay. Also, fee if he works outside hours of employment or outside the county. Okay, 730. Whoa, we do this too in the court, so this is good to know. An order of examination. 1. Generally, a court issues an order of examination after arraignment, other than a felony, when it believes that the defendant may be an incapacitated person. 2. If the court is not satisfied with the examination reports showing that the defendant is not incapacitated, it may order that the defendant be examined by a different psychiatric examiner. Otherwise, the action will proceed. 3. If reports show incapacity, the court may conduct a hearing on its own motion and must conduct a hearing upon the motion of the defendant or the DA. So must conduct a hearing if the DA or the defendant make the motion, but they may do it if they make the motion, the court. 4. If the reports regarding incapacity or danger or dangerousness are not in agreement, the court must conduct a hearing to determine the issue of capacity or dangerousness. 730-40. Local criminal court accusatory instruments. After the above hearing, the action must proceed if the court is satisfied that the defendant is not incapacitated. Goes the regular route. If the court finds that the defendant is incapacitated, it must issue an order committing the defendant to the custody of the commissioner for up to 90 days. If they find that the person is 730, the exam is done, and they find them incapacitated, must be committed to the custody of the commissioner for 90 days. If the accusatory instrument was less than a felony, the court must issue a final order of observation. Final order of observation if it's less than a felony. So this is a lower criminal court final order of observation. If the court issues a final order of examination of what? Okay. For a felony, must issue a temporary. Oh, okay. Okay. Local criminal court, if they're found incapacitated, custody of the commissioner 90 days, and must issue a final order of observation. Good. Felony must issue a temporary order of examination unless the DA consents to a final order. I think it's supposed to say temporary order of observation, but I'm not sure on that. Okay. If the court issues a final order, it must dismiss the accusatory instrument. Again, if the court issues a final order, it must dismiss the accusatory instrument. If the defendant is in the custody at the end of the temporary order of examination of observation, the court must dismiss the accusatory instrument. If a charge in a local criminal court is subsequently presented to the grand jury, the grand jury need not hear the defendant unless it determines that he is not an incapacitated person. If the indictment is filed after a local criminal court accusatory instrument is filed, then the DA must notify the local criminal court of such arraignment, and examination reports must be sent to the superior court. An indictment to be timely must be filed within 6 months. An indictment to be timely must be filed within 6 months after expiration of the temporary order of observation. If a person is not charged with a felony or is convicted of a charge less than a felony, the court must 1. Issue a final order of observation not to exceed 90 days. This is on an indictment, right? Yeah, on an indictment. And dismiss the indictment. If the indictment charges a felony, or when the defendant has been convicted of a felony, it must issue an order of commitment not to exceed 1 year. I'm so confused, but I'm reading this anyway. Superintendent of an institution may, within 60 days prior to the end of the commitment period, apply to the court for an order of retention, which is 1 year. The superintendent must give notice to defendant and mental hygiene legal services. Oh my God, it's in this, mental hygiene legal services. The defendant and mental hygiene legal services may demand a hearing, which must be held within 10 days of when the notice of the application was given to them. Request for a subsequent order of retention may be made as per 2. Subsequent order of retention, 2 years. Okay. I could see this being asked because we have mental hygiene law, Article 9. So I could see this whole thing about procedures following custody of the commissioner this whole thing. I could see this like somehow being on there, but I could be totally off. Who knows what they're thinking. Okay, so generally when a defendant is in the custody of the commissioner pursuant to a temporary order of observation or an order of retention, the criminal action pending against the defendant in the court that issued such order is suspended until superintendent of the institution in which the defendant is confined determines that he is no longer an incapacitated person. When the commissioner discharges, releases on condition, or places the defendant in less secure status, such as vacations, furloughs, and temporary passes, he shall give at least 4 days written notice, excluding Saturday, Sunday, and legal holidays, to the following: 1. The DA. 2. Superintendent of State Police. 3. The sheriff of the county where the facility is located. 4. Police department where the facility is located. 5. Any person reasonably expected to be a victim. 6. Any other person court may designate. Such notification shall also be given immediately upon the defendant's departure without authorization. Okay. Another time rule here. When a defendant is in the custody of the commissioner on the expiration date of a final or temporary order of observation or an order of commitment, or on the expiration date of the last order of retention, or on the date an order dismissing an indictment is served upon the commissioner, the superintendent of the institution in which the defendant is confined may retain him for care and treatment for a period of 30 days from such date. If the superintendent determines that the defendant is so mentally ill or mentally defective as to require care and treatment in an institution, he may, before the expiration of such 30-day period, apply for an order of certification in the manner prescribed in the mental hygiene law. Oh my God! An order of certification in the manner prescribed in the mental hygiene law. And where is that? I don't know where that certification thing is, but I need to find it because I feel like that would be good to know to go with this video. I'm going to have to find it.